just like
suit or
everyone else.
something. Yeah.
And that, of course, is done because of the perception that people have when they.
What is everybody? Welcome back. Truth and Transparency. Appreciate you being here. We are just about 65 minutes out from the live hearing for Charlie Kirk, his alleged shooter, to have, should he be shackled? Should there be cameras? Should he be able to be in street clothes? Welcome. Come on in. I was listening to this earlier.
They see somebody in jail clothes or with
Or
handcuffs. They think, well, they must have done something. I would say this: typically, we don't allow that for preliminary matters.
Right.
Typically, we save those two conditions for in the presence of the jury, and we're a long way from a jury trial. We're probably 2 years away from a jury trial. But you want the jury to see the person just as you and I are presented today. Street clothes, no shackles, nothing like that, because it sort of hurts the whole presumption of innocence thing if you're dressed like that. So they filed that motion, and the judge preliminarily granted it. But then the state came in and filed a response, and the defense is now saying, "Hey, wait a minute."
First of all, let's talk about this. He's missing a big part here. The judge ordered it, and he ordered it prematurely. Didn't give enough of the days to pass where that the state could respond. So that was the big problem right there, is that the judge, who is new, by the way, he prematurely ruled on the motion without the number of days allowing the state to respond. So yeah, that's important.
Our case is against the state, not the sheriff's office. They've sort of attacked the pleading of the state, saying, "Hey, our beef is with the state, not the sheriff's office."
So explain that to me.
Okay, so let me say what's going on here. Ultimately, part of the issue here is that if you want to have Tyler Robinson in the courtroom, no shackles, street clothes, the issue is that we have to provide a safe environment for him. We have to be able to transport him safely. And the people that are in charge of that is the sheriff's department. So the state's over here like, well, our opinion on this is going to depend on, we're going to talk to the sheriff's department. Can you do this? How's it going to affect courtroom security? Things like that. And I will say this, absolutely, you should be conferring with the sheriff's department. You know what? Have him up as a witness, man. I don't know. But I think that there is some bias there when you go ahead and you file a joint motion with the sheriff's department and the state, and it's just the appearance of bias. So, I mean, I don't know. That's what I think it looks like. It's just the appearance of bias.
Because it's not clear to me what they're arguing, actually.
Yeah, so what happened is this, and the pleading has been sealed, so I'm guessing, because I've tried to look it up, but I can't find it. There was a response filed to the defense motion that he appear in street clothes and out without shackles.
Okay, so we actually have that motion here, and it was 9 pages. I'm sorry, 21 pages. Let me grab it. They cite the Bryan Kohberger case. So 21 pages, yes. And she had to ask for leave, first of all. Catherine Nestor asked for leave to file this defendant's motion to appear at all in-person proceedings in civilian clothing and without restraints. And this is her memorandum in support. So we're starting early. If you guys want to see this, it's interesting if you coming off the Bryan Kohberger case. But they cite it. So here, I'll pull this up for a second. And there we go. Make it bigger too. What's up, everybody? Happy Monday. Happy Monday. So here it is. Defender Tyler James Robinson, by and through the undersigned counsel, hereby moves the court for an order permitting Mr. Robinson to appear at all proceedings in civilian clothing and without physical restraints, as articulated herein. This motion is grounded in Mr. Robinson's right to a fair trial, due process of law, the presumption of innocence, and to a reliable penalty determination under state and federal constitutional provisions. So things have changed, you guys. Okay, this normally would not even be an issue because no one's like watching court pretrial motions and hearings, and it wasn't a thing before. Okay, now it is. Now people are, hey, I want to watch this hearing. Hey, I want to see what, they're following all the motions and the hearings that the defendant is attending, leading up to the day and the days of their trial. So this needs to change. This needs to change because of the access, the ability to access and people watching and the internet. It needs to change. It needs to change that you should be able to, you are innocent until proven guilty. Therefore, I am going to be a defendant and I'm going to look just like anybody else would. I don't need to be in no jumpsuit. I don't need to be in shackles. I don't need to be people hearing, no. And if people are going to be following this case or any case, they should never see this person in restraints, shackles. And that's why they wanted the camera off at the last hearing. And they wanted this to be sorted out. Same that Ann Taylor was moving towards, that every little move that my client makes, and the same thing that Catherine's saying, is being scrutinized. Okay. And if he's restrained in some type of way, that's why he's moving in a weird or unorthodox way. I agree with this. I agree that if you are innocent until proven guilty, and then therefore you should have the comfort of being viewed in that light. It's just as simple as that. Now, to try to sit here and say that there's the argument of the safety of the, hey, we're trying to keep your client safe, man. Well, explain to me how him being unshackled, are you trying to say that he's a danger to the people that work at this at the sheriff's office, or are you trying to say that he's a danger by him being unshackled and not and in street clothes? He's a danger almost to himself, because then he could be a target of what? I mean, I don't understand. So don't gaslight us. What's the issue here? What is this courtroom security? What is these security measures that, oh God, the sheriff's office can't handle the fact that this man would be in regular street clothes and not shackled. Yeah, but none of that. We have electric vests worn under clothing. Yeah, none of that though. That's the same thing. That's what's making you appear awkward. And when you're sitting all stiff and you've got to move like that, that's the appearance that somebody needs to be. Why would anybody need to be like that? We have this whole room lined with freaking officers, or even just you would a couple. What is this person going to go do? Now, the argument of not having cameras in the courtroom. I mean, who do these people think they are? It's 2025. Why are you even wanting there to be no cameras in the courtroom? Well, I'll tell you how the defense feels. The defense feels like, well, if you guys aren't going to grant this, then we don't want cameras in the courtroom, because we don't want the entire commentary of the internet that's covering this case to be talking about X, Y, and Z, how he looks, blah, 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 and we're supposed to get a fair trial. Eventually, we're supposed to get a fair trial. No, you're not going to. It's just like Richard Allen. Richard Allen should have those pictures of him. They should have never seen the light of day of him and his you are innocent until proven guilty. It's overly prejudicial. It's totally overly prejudicial, and unfortunately, the world, humans, get it in their heads that, hey, well, you were arrested for a reason, right? Like, okay, that's fair. But humans arrested me. Humans can't make mistakes. I just get upset when I see the gaslighting. When I hear, oh, it's a concern safety wise that the sheriff's office can't do this. Whoa, how? How is it a concern safety wise? I want you to explain that to me. I don't want you to explain some written mumbo jumbo crap. I want the logistics of it. And I think that's why this was a closed hearing on Friday, is because we can't talk about the logistics of how we protect somebody, because we're giving away how we're protecting somebody. Then somebody can then infiltrate that and come in and harm him. I get all that. Okay. I don't want that to be the public portion of it. Okay. I want the arguments. I want the arguments of it to be public. I want why you stand where you stand and what you're basing this off of. But times have changed, and I don't think it's fair that people are seeing, if you're a defendant and you're in the United States of America, you are innocent until proven guilty, and you have the right to appear that way. And I don't. And as a prosecutor, I think that if you're upholding like that, like your burden, okay, just put it on the opposite shoes. Okay. Just flip it. Just flip it. If you're a defense attorney, how would you feel about this? And like the same thing, if you were a prosecutor, if you were the defense attorney, how would you feel about it? And when my case is so solid, yeah, I want to make sure that I believe that person should have a fair trial. I have no problem with them being a street clothes. I have actually no problem with them being, if the shackles or like the problem, what's the problem here? That they're able to be seen, explain that to me. His posture, he was last seen. He was shown before in a vest, a suit that is used for somebody so that they can't commit suicide. That's the one image that we have of him. Unless you go to Facebook or Instagram or something like that, and then even that's those are like 4-year-old photos. So I just think the argument here, I want to hear it. I want to hear the laughable argument, how the sheriff's department is going to say that something isn't safe here by him being in a suit and tie. Okay. So the requested relief to determine motion is, prior to the determination of the motion, the court should order the following: a temporary order allowing Mr. Robinson to appear in civilian clothes and without visible restraints. Okay. Visible restraints at any in-person public hearing held prior to the termination of this motion. Closed hearing for the court to receive evidence, so that, hey, you can have this part be closed. So receive evidence regarding the need for physical restraints in this particular case and the opportunity to further brief this issue. So Mr. Robinson makes 2 requests, obviously, to allow him to appear at all proceedings in civilian attire and to be without physical restraints during all in-person hearings, both pre-trial and trial. These requests are necessary to maintain the presumption of innocence. Exactly. Duh. And I don't see how you can possibly argue this. You guys, Delphi put up this like fence, so when the vans were coming in, we couldn't see the jurors. Okay. And same thing with Richard Allen when his van was coming up, or when it so that you couldn't see him being, transported and stuff like that. If little tiny Delphi could do it, come on. To protect Mr. Robinson's right to fair trial and an impartial trial, and to maintain courtroom decorum and dignity, recognizing that the court must make an individualized assessment of a purported need for physical restraints, Mr. Robinson asked the court for an order directing the Utah County Sheriff's Department to disclose relevant records and for the opportunity to supplement this motion after an evidentiary hearing on the issue of physical restraints. That was not to come out here and file a motion from the sheriff's end. It was to like an order directing the Utah County Sheriff's Department to disclose relevant records. Because like relevant records as to any problems here, was relevant to this, to our order, and for the opportunity to supplement its motion after the evidentiary hearing on the issue of physical restraints. To avoid the very prejudice this motion seeks to prevent, Mr. Robinson requests a temporary order from the court allowing Mr. Robinson to appear at any pretrial proceedings in civilian clothing and without visible restraints while this motion is pending. So either hop to it, or if you want to take a long time to decide this, then he gets to be, that's our request. And a further order granting a closed hearing at which the court can take evidence regarding the need for physical restraints in this particular case. And there's a footer there. Such a temporary order has precedence. A similar request was granted in another recent, highly publicized death penalty case in Ada County, Idaho, while the underlying motion was litigated. There you go. So I wanted to show you guys that if you're following this case, there you go. Order temporary granting defendant's motion to wear street clothes. That's Brian Kohlberger's case. So yeah. So welcome. What is good? What is up? But I like to then hear how people want to talk about stuff. So let's go back to this and let's hear him describe this now.
And in part of that response was something from the sheriff's office saying, hey, this is a public safety issue. Don't make us go through this. We don't think it's safe for us to have to do that. And the defense attorneys are saying,
You don't even have the right to answer.
You don't have a dog in this fight. We want to hear from the county attorney's office. And let me say this. We deal with this issue all the time. And so let's say I have a client in jail and I'm in front of a judge and I say, my client feels like they're not safe. The prosecuting attorney can't order the sheriff to move them to a different cell.
Sure.
Or let's say your client's got, needs a root canal. He's suffering.
Yeah.
The prosecuting attorney can't order that he see a dentist. So the jail does have tremendous authority and leeway in the handling of prisoners in the state of Utah because that's what they do.
Right.
If you consider good time, if you consider work release, if you consider ankle monitor, all those things, a judge can say, go to jail for 90 days, and the sheriff can say, I'll let you out tomorrow with an ankle monitor. You know what I mean?
Yeah.
Or medical care, like I talk about, things like that. If you're in an unsafe environment or you need.
Dude, wait, what? I was listening to this and I was like, damn, who wants to be a judge when you go be the sheriff and just run that town? Utah, what's going on? Anyways, so again, we heard the big key word there, which was, wait a second, why are you putting us through this? Meaning us, the sheriff's office, through the fact that it's a public safety issue that he be in street clothes. Excuse me, but how? How is it a public safety issue that he wears street clothes? That sentence isn't going to fly. Okay. You need to explain that. You're going to need how. How is anybody going to be that's working there? How is it a public safety issue if he is in a freaking suit and tie and no visible restraints? And explain that to me. And the answer is you can explain it. But my response is that nothing will ever be good enough for me to hear that how a man in a suit and a tie is causing a big problem for the sheriff's department. What? I mean, I'm being serious. Like, what can you what's the argument here? What is the argument? How do you not feel like a complete idiot to even comment on that it's a public safety issue? Is it because you guys wouldn't know that he's a prisoner? He may fool the people that work for you. They're just not smart enough to understand. Like, I mean, what's the problem here? I don't get it. You guys, people are gonna like you're gonna say, oh hey, like you don't know what he looks like? When he hops out of the van that says sheriff, and when he hops out, you're gonna just be like, oh my god, what are you doing in here? You're not one of our inmates. You need to just go. This is so stupid. I just want to hear the argument. I want to hear somebody make an argument that having him in a collared shirt and khakis or a suit and tie, wow, we have a problem here. Like our guys may see him pop out of that van that we're transporting him in and may just, oh my God, you're free to go. But this isn't the right guy. Clearly he's not in a jumpsuit. Oh my God, you can just leave. Oh my God, we have the wrong guy.
Mental health treatment. Those are decided by the jail. So it doesn't surprise me that the state.
And then they're going to say, well, no, what if he escapes our men, right? And then everybody out there in the public, that once he escapes us, they would know that they're in danger when they saw him in the orange jumpsuit. And now if he's in civilian clothes, if he escapes us, nobody's going to know that he's a threat. So you think that this man is going to be able to escape during transport. And if he does, and when he does, that the public is not going to know that he is an inmate because he's not in his, jump attire. And he's just going to do what once he escapes? Run around and just start strangling people? Yeah, it's just, we can't have this. Okay. When's the last time that happened? When's the last time that somebody in suit and a tie, when's the last time you had a problem doing this? That's what I would ask.
They did file something from the sheriff's office saying, we think there's a public safety issue.
Right.
I'm a little surprised that the defense is now saying, hey, sheriff, you don't have any say in this, but I think the sheriff has a lot of say in how things are handled, especially when
they don't have a say in how they filed it jointly. That's what they're saying. Not that they don't have a say in it, because clearly she wrote the motion right here. And it says that the sheriff's department should be giving up documents. Not that they have the right to go and file or join that they file a joint response. That's ridiculous. Like, I would have a problem with that. It makes it seem like the sheriff's department is supposed to be, hey, it was the defense that asked for these documents, to be asked for. And then here, all of a sudden, the sheriff, they just talk amongst themselves, the sheriff and the state, and they just together file a joint response. I've never seen anything like that in my life. Meanwhile, this is just over some evidence of how this could be, we want to have an evidentiary hearing here as to if you're going to try to say no, why, how, what. But you see how these people make big deals out of nothing, and you wonder why the country is how it is. This literally has taken on like a ridiculous path that it didn't need to.
deals with public safety.
So if they're saying you shouldn't have responded, we want the judge to throw out this response, can now the county attorney's office respond and say the same thing?
Then they'll have to, and do the exact same thing. And so the judge, I think, is scheduling some sort of a, in camera, which means in private hearing. He'll have a hearing where the public doesn't appear.
And that happened on Friday, because I don't think we should hear about, the intricacies of how they run the inmates and how the safety and all the with all that, how that works. We shouldn't know about that. That should be in camera. But by God, if you're going to sit here and tell me that Tyler Robinson being in a suit and tie is a public safety concern for me living in Utah, wow. Like, wow. You want me to believe that? And there's people out there that are saying, yeah. Why are you saying yes? Where are you? Are you at work? So you think Tyler Robinson showing up in a suit and tie is a safety concern for you? Why? How? Like idiots. Bunch of fucking just stupid. No. Like I said, times have changed. Well then, and let's say that I agree with you. Let's say if I'm a judge and I agree with you, hey, you know what? It might be a safety concern. But guess what? You guys are going to find a way to make it work. Because I do agree that Mr. Robinson will be judged if we are going to have cameras, right? Which that is what I want. I want transparency going on in my courtroom. And therefore, every little move you make as a defense attorney, you make as a prosecutor, and you're on camera. Mr. Robinson's here, and he does. Every little thing is being scrutinized. Okay, that's the day and age we live in. And it's not just to the 30 or 40 or 50 people that could get into a courtroom before, hey, we're at max capacity. No, we have cameras in the courtroom. And if we're going to have cameras in the courtroom, my client has this right. And that's how it should be. Sorry, but and you should treat it as an individual. You guys, Taylor Shabiz would have still done the same thing. Your hands don't get frozen just because they're like this. You can still do things, and Taylor Shabiz would have still, her lawyer sitting right here, taking her hands, whacking him. That has nothing to do with anything. Even, okay, well, you want to restrain her how? Well, we got to put her in a straitjacket, and she's not going to be able to have her hands out and about, But I think that if anybody was going to try to argue and say that that's going to be your argument to have this happen, well, every case is individualized, and that's an extreme. So that's me. Is how has he been behaving when he's been at the sheriff's department, and that's what I think that they wanted, was those documents. And here they're talking about it's a public safety concern.
And is not familiar with what's going on. And maybe someone from the sheriff's office, maybe the sheriff, will come in and say, hey, don't make us do this. I mean, it's going to put the sheriff's deputies at risk. It's going to put others at risk. It'll put Tyler Robinson at risk. Right. Let's face it. Because in Utah County, unlike most counties, the jail and the court are not even in the same city. Yeah. I mean, you go to Davis County, there's a walkway between the jail and the court. And most every other county, Salt Lake and Utah, are different because they have jails. In Salt Lake, it's in South Salt Lake, and in 4th District, it's in Spanish Fork, where the courthouse is in Provo. There is one in Spanish Fork, but he'll be at the one in Provo. So they've got to get him out of the jail. They've got to put him on a bus. They've got to drive him from the jail to the courthouse on a day when everybody knows he's got court.
Right.
Anybody that wants to, and it's not like they're going to be driving an undercover Prius. I mean, they've got the Utah County Sheriff's Office van.
Right. I've seen them. Yep.
Right. Yeah. So, I mean, I think that the sheriff has every reason to feel like.
So you guys think, like, do you hear these arguments? So if he's still restrained, we still know he's leaving. And he's getting into a van and he's being drove. Are you kidding me? We still know that. We can still take down that van. And then even if he's shackled all up, has whatever, you don't think that we have tools to break him out of that once we get him? If you think so, your argument isn't even relevant, because your argument, you think, well, then maybe you should have a black SUV. If that's then that's what you can do. If that's what you want to do, and have a black SUV so nobody knows. But that has nothing to do with the fact that if they wanted to break him out in during the transport, that's still going to be there. This is wild to me. That's the worst argument I've ever heard in my life. because that has nothing to do with that.
Whoa, this is going to be very uncomfortable for us. Maybe they move him 2 or 3 hours before court and just hold him in those little holding cells, which are awful, by the way. It's not someplace you want to hang out very long.
It's interesting. So I'm seeing that that the judge said he could show up for the October 30th hearing, which is next week, as you've pointed out, in street clothes. But there's going to be another hearing to talk about whether that can be a thing ongoing. And so I was curious because I saw a news article saying that hearing to talk about his clothing was going to be closed. But I think you helped me understand that it's probably because they have to talk about security measures.
Right. And you don't want the world to know about that. If the security
This is what the courtroom has in place.
Thank you. That's the only reason that they had a closed hearing. There you go. Now you guys get it. Helping everybody out one step at a time. Come on in. Woo, Tyler Robinson. I mean, this is a no-brainer. We would all be deserving of having him in street clothes, ourselves in street clothes. Again, especially if you're going to have cameras in the courtroom pre-trial, you have to. Or you don't have cameras in the courtroom pre-trial so that, but then think about this. Just because you don't have cameras in the courtroom pre-trial, you have all the people, the media, that are standing around swarming the building. And you think that you're going to be able to pop him out like they were Richard Allen, pop him out of vans and stuff? That's the case that I would be using as the example, that Richard Allen, in between going, like, before he gets in the van when he's leaving the sheriff's office, wherever he's being held, before he leaves there is when he needs to be changed. That's where the whole changing of going into like street clothes would happen. Before he then is any chance for him to be taken a picture of. And that's the only place that I think that you can guarantee that is if it happens at the sheriff's, office. And then wherever he's being held. And then they're getting in the vehicle, coming out, and then he's being walked right in right after. And I'm telling you why you would have to do that is because if you think there's not going to be mad cameras, not just cameras, but rolling film, it's going to be all over there. Think about this. Did we ever see P. Diddy? You know how many cameras were all over that courthouse for P. Diddy? I didn't get to see P. Diddy getting walked in. Right? This is just a no-brainer. But just to keep hearing that this is a safety measure, this is a safety concern, our deputies are not going to be safe. I need you to explain to me how that is. Because this just saying that isn't good enough. You're going to have to say why. And that's all I hear is I never get the whys anymore. It's just, this is what, we're not safe. How? Why? Explain to me what your fear is. What are you in fear of?
This is what we're going to do to make sure he's secure. We're going to drive this specific car. We're
Right,
going to leave
at
this
this time.
specific time. We're going to bring him down this sally port on this end of the courthouse. No. We want to do all that in as much silence as possible. The other issue is his coming out in shackles. I mean, I don't know. So he walks out of in the courtroom. There's a little holding cell to the side of the court. They walk out. They're in the courtroom itself, and they walk out to counsel table, which is in front of the judge. And we have them walk out in shackles all the time. You see them there in their jail clothes and their cuffs. They want him to walk out like anybody else.
Right.
I mean, that poses. I mean, there's a risk of flight, but I don't know that he's going to run because I'm sure there's going to be a wall of bailiffs behind his defense table to make sure he doesn't go anywhere. And I don't know that what I guess another problem could be people from the audience being able to get to him.
Right.
But the same wall applies there. I don't know that he's a threat to himself or anything else if he's not cuffed. And there's no way somebody's going to get into that courtroom with a gun or in some way able to hurt him. But I don't know, the cuffs would make a difference with that. But the whole idea of shackles is a bigger problem for the sheriff, I think, than the street clothes. I mean, you got to dress him out, which is a hassle. But having him not in shackles is one thing that makes the law enforcement really nervous. Just to have him walking around like anybody else. I mean, what if he strikes someone?
You didn't read it. You didn't read it. It says visible restraints. Visible.
What if he runs?
Well,
or
and
what
there
if
have
somebody
been
attacks him?
there
Right.
have been cases, right, where
Absolutely.
people have done that. So
Right.
there was a shooting in a court in Utah, right? I think a bailiff was shot maybe by somebody who was
Yeah,
appearing
and there was a
before
federal
judge.
court hearing where a
Yeah.
guy
Well, that sounds like a Utah idiotic problem. How the fuck did the gun get in there? You know what I'm saying? Like, are you kidding me? You guys don't have metal detectors? I mean, what the fuck?
jumped out of the table and tried to stab the witness that was testifying
Yeah.
against him. I mean, things like that can happen. Often, when you're in front of the jury, they'll put like a curtain or drape on front of the defense table, in front of all the tables, so it looks the same. A
Okay.
sheet, if you will.
So
Yeah.
they're shackled, but
So
you
they're
can't
shackled,
see it.
and they're shackled at their
Yeah.
ankles, so
Yeah.
you can't see it. Their hands are on the table. They're writing
Right.
down. They're talking to
Right.
their attorney. They're wearing
Right.
a nice shirt and
Yeah.
tie,
Yeah.
but they're not going anywhere because
There you go. What's wrong with that? What's wrong with that? And I think the issue is going to be this. I'm fine with that when he's sitting down. But when he's going to be walking,
shackled, sometimes cuffed to
Yeah.
the table itself.
Right. We don't have a whole lot of time, but is there any speculation about Tyler Robinson being at risk from somebody wanting to assassinate him for what he did to Charlie Kirk, allegedly?
But there's every indication of that. And that's another reason why I think the Utah County Sheriff's Office is on high alert.
Yeah.
He's probably in protective custody.
so that's your best argument is that we have our deputies standing with this dude, right? And they want to kill him. People want to kill him, right? Well, guess what I'm going to tell you? My response to that is that's your best argument is that people want to kill him. If they miss, they kill one of our deputies. Okay. Well, guess what? Don't you think that that person is going to be trying to do that regardless if they are in restraints or not? They're going to be going for a headshot, right? So that's my argument back is being in shackles or restraints and being not in street clothes, that has nothing to do with that person saying, you know what? I'm not taking a shot because I actually think that street clothes could potentially, all right, deter somebody from doing that because the orange is more of like a, hey, here's your target. Someone's in street clothes, they can't find the target as easily. I don't know, but that's your best argument. But the argument back to that, and it still would lose, is that are you sitting here saying that somebody is not going to try to assassinate him if he's in street clothes? Because they're still going to try to assassinate him, meaning taking out Tyler Robinson. I hope we both. Yeah, there's a hearing. I mean, there's definitely a hearing.
He's probably alone. He's probably not with other inmates.
25 minutes.
And in a place where he could be hurt, even by, I bet he's under 24-hour surveillance too, just from the guards and other people. But I mean, he's got to be a security nightmare for the sheriff. And the defense have arguably made that worse, or at least more difficult for the sheriff by saying, hey, let him show up in court with street clothes and walk in with his sneakers like everybody else. And the sheriff's like, come on, I can only do so much.
Yeah, interesting. I know I've seen online people who have saying just take him out and apply the death penalty right now.
Yeah, which obviously we don't do in America. And he's going to get a fair trial. He's got good counsel. They've got good attorneys for the state, and it's going to go forward.
New at 4, the accused Charlie Kirk shooter appearing in person in court for the very first time this afternoon. It is our top story on 2 News at 4 today. I'm Heidi Hatch.
And I'm Jamie McGriff. Thanks for joining us. The public was not allowed in the courtroom today. 2 News investigates Chief Investigator Wendy Halloran is joining us now with why this hearing was closed. Wendy.
Well, Jamie and Heidi, today's hearing was for the judge to hear from the prosecution and defense on whether or not Tyler Robinson can wear civilian clothes in court and if he has to wear shackles. Robinson's attorney, Kathy Nestor, filed the motion 2 weeks ago asking for the closed hearing. She argues wearing plain clothing and appearing without physical restraints are a part of his right to a fair and impartial trial and the presumption of innocence. She notes throughout the filing the massive media attention the case is receiving, saying the world is watching Mr. Robinson and these proceedings, arguing seeing him in a suicide robe, bulletproof vest, and shackles will make it difficult to get a fair trial. We talked to Sky Lazaro, who is not involved or affiliated with this case, about why Nestor would want Robinson unshackled and in civilian clothes.
And in a case like this, it's getting so much publicity. You want prospective jurors to see your client or the defendant as a human being, instead of parading them in and out of court in shackles and in jail garb, which just tends to make people believe that they're guilty.
That's exactly what it does. Sorry, nothing I can do about the fact that they are rolling with a very quiet audio there.
So there was an interesting article or interesting
But this is scheduled to start in 21 minutes, by the way. I'm going to hear a couple people.
In the meantime, attorneys for the suspected shooter of political commentator Charlie Kirk claim the Utah County Attorney's Office is acting with the sheriff's office to prevent their client from wearing civilian clothing to his trial. This claim is hoping to strike the request that denied Tyler Robinson from wearing that civilian clothing and prevents him from being without restraints in court in just over a week. His attorneys claim if he comes in a jumpsuit and shackled, there could be a bias against him. This new claim alleges the sheriff's department does not have any authority in this decision. It's unclear whether that claim would be heard before his set court date, but it is unlikely Robinson will appear in normal clothing.
I mean, I'm sorry, but wait, what did she just say?
Not have any authority in this decision. It's unclear whether that claim would be heard before his set court date, but it is unlikely Robinson will appear in normal clothing.
Idiot.
For his set court.
Right there. This is what should not be allowed. Okay. That's ridiculous. Sorry. That's not even shackles. That's not even this is that's why mainstream media doesn't get it. Yeah, he's definitely wearing street clothes. Or I mean, do you want this man to have another trial? I just don't get it. Do you want to do this all over again? Now a new document has dropped today, and the Utah is saying, hey, come on out and you can view all of the evidence that we have against your client. When was it filed? Request to submit. It was the state. They fired back and they said, we have, hold on one second. They're having an issue over evidence too, so. Oh, this is discovery stuff. Oh man, where is it? Okay, it is a. Yeah, on 10/27/2025, notice of state's open file policy. So that was filed today. And it says that the state by-in through Chad E. Is it Grenarder? I don't know. He's the attorney though for the for the Utah County Attorney's Office, and he said, "Hey, counsel, come on out, and you can." The state also invites the defense to inspect all physical evidence seized by law enforcement in this matter. This is just physical evidence seized, as found in the state's discovery letter provided to the defense. So, counsel of record may, by appointment, come to our office to review a file. In fact, we urge you to make such an appointment prior to any case going to trial so that we can ensure we have provided you with all available information received by this office. We will also ask any evidence custodian to make physical evidence in their custody available by appointment for your review and inspection. I'd be hitting up the FBI like a mofo. You should, of course, expect the evidence custodian or an officer to remain present during such an inspection to preserve our chain of custody. Submitted this 27th day of October. Now that's just to inspect it. Because she put in a discovery request that they had 5 days to do X, Y, and Z. So there's that. Let's pull up this hearing that's set to start here in I'm going to go with Utah ABC.
In the meantime, attorney.
Actually, I'm going to go with Milwaukee. Yeah, fuck it. Fox. Yeah. 16 minutes. Oh, let's see. That's a UK channel. Fox has a countdown on. All right. Again, what is up, guys? Welcome. How's everybody's Monday? Just another Monday. Well, tonight I'll be live. Actually, when this is over with, I got some explosive Idaho 4 stuff. I got some explosive hidden true crime gem stuff. Explosive Vicky Gooch, Dylan Mortensen bombshell. Like, whoa. And Taylor would have been calling Vicky Gooch to the stand. Vicky Gooch says that she recorded that interview. I wrote the Idaho State Police and they said that they are not in possession of anything. I'm like, here's her report. She said that she recorded it. And now the Idaho State Police is saying that we're not going to turn over anything. So I think they're going to make the, I think Idaho is going to make them be sued. I think someone's going to have to sue Idaho if they want stuff. I'm all for it. Let's sue away. I really wish Taylor, I don't know who you mean, Tyler, had stepped to the mic. Yeah. Well, I really wish that, I just hope that all the evidence comes out. Because the more and more you look at something like this, the actions of the vehicle beforehand, the ring cameras, the actions of the vehicle afterwards, if he's in it, that there was definitely another vehicle involved, a white SUV. So, notify me. I wonder if Turning Point USA. I know that Candace, she's coming back today. I think she's doing a live. She says she's got receipts, and she's got receipts that everybody has literally betrayed Charlie Kirk. You know, we'll see. I want to know why Charlie Kirk's people were looking through the grass area on the stadium style like seating there. What were they looking for? Why are you going through and like looking on the ground? They were looking for shell casings. Why? If somebody shot from the roof, you know? Maybe they were just going to come out and say that we just did it as a precaution. We didn't know where the shot came from. So when we went out there and we were just looking all around in the grass there. Okay. I'll tell you this. They have cameras that they were just so concerned about getting right away. And those cameras should have been seized by the FBI, right? Whoever was investigating. Hey, you're going to give us this, this, and this, right? If any of these cameras, as we find out later on down during this case, come to light that the camera, oh, it wasn't recording or blah, 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 something along those lines, I'm going to go irate. Also, if it comes out that Tyler Robinson's family, and it did not go down the way the sheriff friend is explaining it, I will be irate. I will be literally irate. Because I am so sick and tired of the narratives. I think that sheriff is making overjudicial statements. And I have no idea what the hell he's thinking. But guess what? He ran his mouth so much, right? Gag order. And it wasn't even asked for by either side. Judge imposes the gag order. Horrible. So today's episodes, we have this to cover, and then we have hot damn. We got things are so hot with Scott Peterson's case. Oh God. Not only that, obviously the Idaho 4 case. Idaho State Police are claiming that they turned everything over to Moscow Police Department. And so that would mean the Moscow Police Department, we have to go through, Latah County. That's either like Idaho State Police wanted to wash their hands. Hey, we're not going to be getting involved in this whole like paying for FOIAs and blah, blah, blah. You know what? We're going to give them to you. Like, we're giving everything to the investigating agency. Okay. And you guys can go ahead and do this. But I want to talk about all the exhibits that were in the prosecution's possession and control because they made exhibits. I want all of these. I want what you were going to try to use to have a case against Bryan Kohberger. This stuff. This 28 pages of this Excel spreadsheet that has listed just everything that's on there. Let's go. Saddle up. Both sides requested no cameras. Yes, but for different reasons. The defense requested no cameras if you're going to have my client in shackles and not street, in jail garb. That's why they're requesting that. If you get your wish on having street clothes, okay, and no shackles, right? then what's your argument to have no cameras? You don't have one. Also, people are talking about how Diddy was federal. You guys, it doesn't matter if Diddy's federal. Obviously, yeah, it's not going to be live broadcast, but going in and out of a building, okay, how come Diddy was never seen, though, going in and out of the building? Because they arranged it that way, right? But we never, how could all the mobs of cameras not possibly get a glimpse of Diddy walking into that courtroom? These guys in Utah act like they have no idea what they're doing and that they can't possibly put up a little fenced area and put the black around it and back up a vehicle and let somebody get out so that someone is not seen. They act like they don't know logistics. Okay, go hit up the nearest warehouse and talk to the warehouse manager who runs the logistics department. Okay? Yeah, I think it'd be perfectly fine. Just everybody has an argument, but they don't argue. They just state something and they don't make an argument though for it. It's like we're like 5 again and our mom says, no, you're not going to do that. And no, you're not going to hear that. And you're just like, why? Because I'm your mom and I say so. Like that cuts it until that cuts it with your folks. It doesn't cut it here. So 7 minutes until this hearing will be underway, which is supposed to start at 3:00 Eastern Standard Time, which is 1 p.m. Mountain. We'll see. Everybody's streaming it, though. We have Philadelphia. We have Fox Business, Fox News, ABC Utah, USA Today, Milwaukee Journal Centennial. I mean, you have to put this man, you have to put him in street clothes. The world is literally watching. Also, Lauren Matthias better be out there. She just had her case in Provo, Utah, right? She wanted to put her own case in Provo, Utah. She better be out there. Rumor has it she's shopping jurisdictions to move her stalking case to a jurisdiction that will take care of it. I think her and Dr. John have completely lost their minds. If you want to see Hidden True Crime before they became Hidden True Crime, join me tonight at 8, and then join me at 10 for, yeah, there's a bunch of stuff, but this is just, I've never heard of somebody shopping jurisdictions to, hey, if Provo, Utah, John said if Provo, Utah isn't going to, give us what we need and we're going to, yeah, we'll go somewhere else. What? You live in Nevada. Why didn't you go? What do you mean you're go somewhere else? You guys, they wanted to make sure that this has nothing to do with, you didn't even go to court. You got your ex parte, and he's basically admitting that they weren't going to get it. It's just mind blowing. And then everybody's blowing up her spot because she's over here saying, wait, I just didn't go forward with it because I didn't want my son's trauma and our trauma and blah, blah, blah to be aired on Law and Crime. She never said I wasn't going to get it, and that's why I didn't do it. But then Grayson and Dr. John, they're talking and yapping. And then they're basically saying what we all knew, which is you weren't going to get it and you should have never gotten it. But to think that she went to Provo, Utah to make sure that she had personal jurisdiction over the stalker. That's why she did it there, because so they would have, like, the stalker couldn't claim that you don't have personal jurisdiction over me, in Nevada. So yeah. She goes out of her way to do all of that. She better go and report on the Charlie Kirk case that she lives. I didn't even realize until this whole thing happened that she used to live in Idaho. Didn't even know that. Then moved to Nevada. And literally lived in the same town as the Vegas shooter, allegedly, and then files in Provo, Utah. Really hard to follow it. So, but I've never heard of someone shopping jurisdictions. And then she talks about that she just might go federal with it. A federal stalking case. A federal fake stalking case, guys. We have 3 minutes and 15 seconds before we're supposed to be kicking off. And yeah, dude, I get a nice little chuckle out of that. Thank you for being here. You could be anywhere listening and you're choosing to be here. So thank you. Thank you, moderators. Chad Pitt and Lori Jolie think they are making characters. That's too funny. I agree with Amanda here on this one. The entitlement is out of control. OOC 100. You know what else is OOC? Is the NBA and the NBA players, the FBI. I mean, you guys, I'm going to break all of that down. None of that makes any sense because who in the world is throwing games, is throwing overs and unders for a finder's fee of $2,500? Nobody. Why in the world would, I mean, think about the logic here. You make $256,000 a game. That when you add it all up, it's like $26 million a year. Who in the world would ever be involved in something that's kicking them back? Okay. Pennies. That doesn't make any sense. And so I'm going to break all of that down. So with these indictments with the FBI and the NBA and these players, it's like something's missing here. You know, something is really, really missing. I mean, these people are betting like and winning like $41,000. $41,000. Do you know what that's pennies to somebody that makes $26 million a year? How about a guy that's getting a $2,500 finder's fee because he told somebody that, hey, LeBron James, he's not going to be playing in this game. He's hurt, but it hasn't come out yet. He got sent $2,500 for that. And so he went out to a steak house and like lived it up downtown where steaks were like, I don't know, $400 or $500. I have no idea. There has to be more to it. And I think that there is, but it just, and anything to get, I feel like everything off of the Epstein shit. Oh, there you go. Who's this? Who's this Smith? I could go down the rabbit hole on this betting scandal and how the WNBA treated Caitlin Clark this season. Yeah, people when begging me to talk about the Caitlin Clark situation. It's absolutely ridiculous. These refs in the WNBA, the WNBA had like literally should have been like praising the ground that Caitlin Clark walked on. And instead, it was bizarre. Okay, we're just waiting for Fox News to kick this off. And then they said that. So we're just patiently waiting as soon as and then I'll make it a big screen. Constance Smith says, let's do this. Huge fan. Yeah. We're pretty big too over here. You know, reinventing WNBA only to just have it be trash. I mean, you're allowing the best player in the league to get injured. Crazy what's going on. All right. Judge Tony. Ghosty host. Everyone wants to see it.
Good afternoon. Court is now in session. Calling case 251-403-576, State of Utah versus Tyler James Robinson. Will the parties please enter their appearances?
Your Honor, Christopher Ballard and Chad Grunander on behalf of the state.
Your Honor, Kathy Nestor, Richard Novak, and Stacy Visser on behalf of Mr. Robinson.
Thank you. Welcome to both prosecution and defense. Mr. Robinson, I understand, is appearing by WebEx. Mr. Robinson, can you hear us?
Yes, I can.
Thank you. Good afternoon to you all. We're here on the Tyler James Robinson motion to appear in civilian clothing and without physical restraints at all pretrial hearings. Because of some of the arguments involved in court security protocols, the court held a closed hearing on October 24th, 2025. During that hearing, the parties addressed several related matters. The first, Mr. Robinson's motion to strike the sheriff's response. The second, Mr. Robinson's motion to appear in civilian clothing and without physical restraints. The third, the sheriff's and Mr. Robinson's request to limit or exclude visual recording and photography in the courtroom. And finally, the fourth matter, the state's request to have all non-evidentiary hearings held remotely. The parties have stipulated that the state's request to hold non-evidentiary hearings virtually, as well as the parties' joint request to limit electronic media coverage, both require further briefing. Those issues are not yet ready for the court's decision. To facilitate that briefing, the court directs as follows. If the state wishes to have all non-evidentiary hearings conducted via WebEx, it must file a separate motion. The court will not rely on prior briefing. The standard timelines for response and reply apply, and the parties must file a request to submit and request a hearing if desired. If the parties seek to limit or restrict electronic media coverage, they may file a joint motion. Again, the court will not rely on prior briefing. That motion must address the factors set forth in Rule 4-401.01 sub 2 of the Utah Rules of Judicial Administration. Standard response and reply times apply, and the parties must file a request to submit once the matter is ripe for decision. The court took under advisement two issues, the motion to strike and the motion to appear in civilian clothing and without restraints. The court now issues its ruling. In regards to the motion to strike the sheriff's response, the prosecution and the sheriff's department filed a joint opposition to the defendant's motion to appear in civilian clothing and without restraints. Mr. Robinson moved to strike the sheriff's portion of that filing, arguing it was procedurally improper because the sheriff is not a party. At the hearing, all agreed that the sheriff's department is not a party in this case. The state and the sheriff's office nevertheless argued that the sheriff may file memoranda as a non-party. Mr. Robinson disagreed, but did not object to the court considering the sheriff's position on security. The court finds that the sheriff's department is not a party to this case, and therefore its joint filing with the prosecution was procedurally improper. Accordingly, defendant's motion to strike the sheriff's response is granted. However, under Rule 3-414 of the Utah Rules of Judicial Administration, the court is required to coordinate courtroom security with the sheriff's department. Consistent with that rule and with the defendant's agreement, the court has considered the substance of the state's opposition and the memorandum prepared by the court security director that was attached to it. Going forward, if either party has a security concern specific to this case, they may present evidence from the sheriff's department by affidavit, declaration, exhibit, or testimony. This order does not limit the sheriff's department's ability to coordinate with the court or otherwise act as authorized by law. Turning to the motion to appear in civilian clothing and without physical restraints. The parties agree that during trial, a defendant has a right to appear in civilian clothing and that any restraints must be concealed from the jury. Mr. Robinson now seeks to extend those rights to all pretrial proceedings. The court considered each request separately. In relation to request to appear in civilian clothing, Mr. Robinson asks to appear in civilian clothing at all pretrial hearings. He argues that the extensive media coverage of this case creates a real risk of prejudice if the public and potential jurors repeatedly see him in jail attire. The state, the sheriff's department, and the court security director opposed the request, arguing that jail clothing assists with safety and identification. The court has balanced these competing concerns. The case has attracted extraordinary public and media attention. Images of Mr. Robinson in jail clothing are likely to circulate widely and influence prospective jurors. Given the scale of that publicity, the risk of prejudice is significant. However, Mr. Robinson's, let me see here. As previously stated, Mr. Robinson sits before this court presumed innocent, and that presumption remains unless and until each element of every offense charged against him is proved beyond a reasonable doubt. To date, this has not occurred, and the presumption of innocence remains. Balancing these factors, the court finds that Mr. Robinson's right to the presumption of innocence outweighs the minimal inconvenience of permitting civilian attire, and Mr. Robinson shall be dressed as one who is presumed innocent. Accordingly, the defendant's request to appear in civilian clothing for all pretrial proceedings is granted. Defense counsel is directed to coordinate with the jail to ensure that this order is implemented, and the court further orders that if the clothing be provided 72 hours prior to any hearing. To the second request to appear without physical restraints, Mr. Robinson also requests to appear unrestrained during pretrial proceedings. He argues that visible restraints would prejudice potential jurors, undermine his dignity, and interfere with his ability to communicate with counsel. Rule 3-14 sub 9C of the Utah Rules of Judicial Administration requires that all in-custody defendants be restrained unless otherwise ordered by the court. The court recognizes that Mr. Robinson has no criminal history and no record of misconduct while in custody. However, the charges he faces are extraordinarily serious, carrying potential penalties of life imprisonment or death. The safety of Mr. Robinson, the attorneys, court staff, and the public must remain the court's highest priority. The emotional nature of these proceedings also raise the risk of disruption. Given these factors, the defendant's request to appear without restraint is denied. The court directs the sheriff's department to conduct an individualized assessment and use the least restrictive restraints necessary to maintain safety. If those restraints impede the defendant's ability to communicate with counsel or take notes, counsel may renew the motion. I wish now to also address the decorum and media restrictions. To mitigate any potential prejudice, the court will amend its standing decorum order. The media will be prohibited from photographing or visually recording Mr. Robinson's restraints and from photographing or recording him while entering, exiting, or standing in the courtroom.
Boom.
In making this amendment, the court has considered the factors in Rule 4-401.01 sub 2. This is a high-profile case with strong public interest. Restricting the recording of restraints strikes the proper balance between Mr. Robinson's right to a fair proceeding and the public's right to access and transparency. In conclusion, the court orders as follows. Defendant's motion to strike the sheriff's response is granted. Defendant's motion to appear in civilian clothing is granted. Defendant's motion to appear without restraints is denied. The standing decorum order will be amended to prohibit any visual recording or photography of the defendant's restraints or of the defendant entering or exiting the courtroom. This constitutes the order of the court, and a written order and ruling will be published shortly. Both defense and prosecution have stipulated to vacate the October 30th hearing. Additional time is needed to complete discovery and to file motions addressing whether non-evidentiary hearings should be conducted virtually, whether to impose any blanket restrictions on cameras in the courtroom, and any other motions that may arise. This matter is set to return before the court on January 16th, 2026 at 1 p.m. and again on January 30th, 2026 at 1 p.m. Both hearings will be heard and held in person with Mr. Robinson present to address these issues. And that concludes the order of this court. Counsel, thank you for being here. Mr. Robinson, we'll see you on January 16th and January 30th at 1 p.m. Court is now in recess.
Okay. So the next date is until January 6th and January 30th. What's going on with his preliminary hearing? It's only October 27th. So maybe he's just speaking about, I don't know, but I was expecting there to be a preliminary hearing. So I missed that end part there, but I think this is very fair. I think it's exactly what I said. The only time that Tyler Robinson is basically screwed is when he is getting out of a vehicle, okay, and being walked in with media trying to get a picture of him like that. All right. And so that basically is going to be like, you can't do that. Okay. And if you do that and you publish it, they better go after those people. Because that's the whole point of it. And then when you're in the courtroom, there's no cameras. You're not allowed to take a picture of his restraints. So if anything with the restraints is in your camera photograph or, the video that you're doing, you can't, publish that either. So I think, this doesn't take away. I think this is what you do. This is perfect. And then you just have to hold people accountable if they go ahead and they try to produce something that they shouldn't, publish it. So I believe that this was perfectly fair. I'm glad I changed it because our rights 2-0, and then if he's unable to properly, by sitting at the table with his defense counsel, if he's unable to partake in his defense and with that, hey, my restraints are doing this, they can revisit that that motion and talk about that as far as the restraints go with being in the courtroom to help defend himself and working with his counsel and talking and stuff like that. Richard Allen had no restraints. I did not see Richard. Did you see any restraints?
No, he did when we had the actual trial, no.
Yeah, he didn't have any restraints at trial. I mean, nothing. It was, I have him as not waiving his prelim, so it's still not, we're supposed to still have that. I don't know. She did what?
Remember, she tried to fight not having to be restrained when she was pro se.
Oh, I don't care about that. That's what I'm talking about. Fuck that bitch. We don't talk about Lori Daybell. I'm gonna fuck about Lori Daybell. Anyways, the next thing that pops up on Fox News is Trump is okay with it. Our rights have to stay intact. Okay, this isn't just Tyler Robinson's rights; it's all of our rights. All right. So, to me, I needed to take down that the defense was 2-0 at the time. It was our rights were 2-0 at the time. Okay. And then I believe there was a fair balance there of, hey, our safety, our rights, all listen, you're going to be restrained, but nobody can take pictures of that going in and going out. And when you're sitting there. Yeah, there you go. And that's for all the pre-trial stuff. Okay. Once he's in trial, he's not going to be, Richard was just walking around like, he was just walking around his little table, when he needed to like, stand up. And I didn't look at him. He was, yeah. He wasn't, his hands weren't like shackled like this. Like his hands were, grabbing the water and drinking a glass of water. Yeah. He wasn't shackled.
There were 15 cops in the courtroom.
Yeah, but they weren't hovered over him or anything like that. And then whenever like the jury would get up to like leave, then somebody would come over and stand over between like just right behind him. But they were awesome with him, I thought. I thought that they did a really good job. Oh, and they weren't dressed like cops. They were dressed in suit and ties. That was the other thing. So they blended in like they could be potentially his defense team. So the people that were protecting us or, watching Richard Allen, they were in a suit and tie. All right, guys, that's going to do it. I think the judge did a great job. And I loved how he said, yeah, the motion to strike. Yep, you out. It's improper. You should have never filed like that. Awesome to see. Thank you guys for being here. Join me back here in a little bit. We got a night full of whoa, wow, bangs. So we're just going to get after it here in a little bit. So thank you again. Appreciate you.